Hello, and welcome to Jane's LME Addiction, a Cloud 9fin podcast where we talk about all things liability management. My name is Jane Komsky. I'm the head of LMEs here at 9fin, and with me today is Jennifer Selendy, founding partner of Selendy Gay. Welcome.
Thank you, Jane. Glad to be here.
It's so nice to have you. You've spent your entire career litigating high-stake disputes. How did you end up in this liability management space?
Well, like most things in litigation, it was a little bit of an accident, but also a fortuity because it really touches upon, I think, a sweet spot for our firm. But a friendly firm had clients. They represent a lot of creditors and had a group of clients that they couldn't represent because of a conflict in the Trimark case. And they called me up and, said, hey, I know you guys you don't have a corporate department. You're not drafting credit agreements, but do you know your way around a credit agreement? I said, yeah, I think so. And asked me if I would talk to this group. And this group was worked up. I have to tell you, a big part of this for folks is disrupted expectations for people who think they're first lien lenders and have fully pari passu rights in a credit agreement. But what we realized pretty quickly was that the folks who have transactional practices that are really deep in drafting these credit agreements might feel constrained in how they would argue a case like this. And so the way we pitched it is, look, a court's going to look at every contract individually in the first instance. Ultimately, if they find ambiguity, they're going to talk about what are our customary terms in the industry, what do experts have to say about this. But they're just going to look at the language to start with. And the question is, does the language allow it or doesn't it allow it? And so I think that was pretty appealing to the folks. We thought that this open market purchase technology, let us call it, was pretty bogus, frankly. And we thought they had the better of the argument. And so we started with Trimark, and it's been a long road since then.
Well, it's funny. You wouldn't know this, but actually my introduction to liability management was your firm's pleadings in Trimark. I remember I read the term, I think it was cannibalistic lender-on-lender violence. And I was like, I need to know everything to know about this. And thankfully, the way that your firm drafted it, it was just, one, it was very compelling. And two, it was actually very easy to understand. So I don't envy having to be the first one to be like, what happened here? How can we write this in a way that is clear to everyone? And from there, I ended up specializing in like this space, and here I am now.
Well, that is great. I think that we tend to think about a pleading from the point of view of actually trial and thinking about the narrative, and it has to be understandable, right? So a credit agreement, I remember thinking when I pulled up a 400-page credit agreement with all the amendments and whatnot, that this is a document that hasn't been litigated very often. And there's just a lot of stuff in here that we're going to have to unpack for the court. And so we start thinking about, like, what is the opening statement going to look like in court? How can we tell a story that's compelling? What's the narrative? And that's how we put our complaint together with that end game in mind.
That makes sense. Yeah. So interesting. And so are there specific sort of trends or provisions that you consistently find problematic and that you find yourself when you're pitching clients saying, and we're back to this?
Yeah, well, certainly the open market purchase was one. I spent a lot of time as we were building the Trimark complaint talking to people that had been in the field, had been who understood when these types of provisions entered into credit agreements. And experts sort of uniformly said, back around the time of the Great Recession, a lot of folks were feeling like their credits were undervalued, and they wanted to have provisions that allowed them, if they had spare cash, to go out into the market and buy back buy back their loans and retire them. And that's how these came about. And so I was like, wow, that we're a long way, we're a long way from there when we get to how they were being used in the liability management context. So I think that what we see, I think, as really important trends that have developed, you and I were talking about this off camera, and that is that ordinarily when you have litigation around contracts, you would tend to see a trend towards less ambiguity and more clarity because the parties on both sides would want that. And I think that what we see in the liability management context is that private equity sponsors and companies really want to have flexibility, but they don't really want it to affect the pricing of their debt. And the lawyers are very creative at, I think, keeping ambiguity in very dense and complicated contracts, or even looking at provisions in new ways that weren't intended when they first entered into the documentation. And so we're not, the parties that are being excluded also don't have a seat at the table necessarily to say, hey, I'm not gonna sign this contract if you don't tighten up this language. That dynamic doesn't really exist all the time. We've seen some tightening of agreements, but we've also seen new ambiguities introduced to them. So that kind of creates a cycle of opportunity for disrupted expectations on the part of the lenders that get excluded, and opportunities when companies feel like, hey, I need some runway. I want to do something a little different here to try to avoid going into bankruptcy. And, I think the lenders themselves, the big lenders, have gotten pretty creative about being proactive for their own part and saying, hey, we have some ideas about how you might restructure your debt that would be beneficial to us. So all the players are active. The transactions have gotten more pro rata to some extent. So there are layered opportunities for participation. But that is not satisfactory to all parties. So we still are seeing groups of excluded lenders, or even just one or two, who are saying, you know what, this is bad, this is wrong, and we want to fight it.
Yeah, I thought one of the more interesting points brought up in STG logistics, which I don't know how much you can talk about given that it's active, but the no action clause, how you sort of mentioned, you're like, this is not what it was intended for. The idea of making sure that minority lenders can't bring valid claims. And so are there any other clauses like that you're finding that started off as one thing and you're seeing are now being used as another thing?
Yeah, I mean, I think just generally that amendment provisions, right? Amendment provisions were meant to solve the holdout problem, right? And they were, the thesis behind them generally was always that a majority would be acting in the greater interest of all the lenders similarly situated. And so there wasn't the idea that you were going to burn the bridge on your way out the door. The idea was that you were going to act in the best interest of the group, and that exit consents, if you will, that was going to happen, but it was only going to happen when the opportunity had been offered on a pro rata basis. And you could have some folks that turned it down. But I think that there's a big role, in my view, for good faith and fair dealing in that context, because the parties' expectations are never that there's going to be these scorched earth amendments where a preferred group of lenders exits and leaves behind a group that has all their covenants stripped, all their rights gone. And meanwhile, as you slide out the back door, you're sliding into a new credit agreement. You're not really exiting. Okay, you're sliding into a new credit agreement that has all those traditional protections. So I think that's something that has to play out over time. Those are really not how the amendment provisions were used and why they came into being. I also think that I am seeing some new technology out there where, after CERTA and the end of the open market purchase string of mayhem, let us say, there are other provisions that I would say are being abused or repurposed for
Do you mean
liability
like
management.
expanded assignment clauses or which specific provisions?
I think basically the extend and exchange provisions, right? So, typically offered on a pro rata basis, there can be extensions of the maturity dates, right? And that's something that is offered to everyone. And a new class is created. And the amendments that typically would be used in connection to that are very narrow, only to implement this extension. But the idea that those provisions get amended so that they're non-pro rata provisions that allow exchanges that are non-pro rata, not how those provisions were intended to be used. But I think that's going to get litigated,
We've been waiting for that. Every time you see one of these new sort of inventions or technology, it's only a matter of time till someone litigates it. But I think a lot of people in the market sort of wonder, well, if they're offering, usually, in the two transactions that we've seen, right, which is Oregon Tool and Better Health, someone was the excluded group, or I guess the people who pulled off the transaction wouldn't call them excluded because they would say they were offered something. They were offered some sort of consolation prize. Yeah. So when you're offered, given how often expensive litigation can be, why would people sort of say, okay, I'm going to litigate this rather than accept just maybe in some cases slightly less or in other cases, half?
Yeah. So I think there are a couple of reasons. So one is that when you buy front row tickets, you expect to be in the front row. And when some people get to remain in the front row and others get demoted to the nosebleed section, that tends to ruffle some feathers, right? So you're accepting something that isn't what you bargained for. And that disrupted expectation always, people see it as setting a precedent. They see it as being victimized. And they think, how can I allow my investors to get less of a return than, the big guy who bought the same tickets that I did? So that's some of the mentality that we see, or some of the disgruntled perspective of an excluded lender. I think the other thing is that in taking the consolation prize deal, right? So not only are you, maybe accepting a bigger discount, you're releasing the ability to challenge the transaction. And if you're if you're not pari passu and the company does go into bankruptcy, there are lots of down the road implications for that, which I think and some lenders then are much better positioned to be working with the company around DIP financing and other things, even, out of court restructurings, having a seat at the table. And if you've released claims, then you've given up a stick. And you may have the carrot that you're willing to put in more money, but we've just too often seen that the big lenders don't invite everyone to the party. And, a lot of our clients feel that it's just giving up too much in an uncertain environment.
No, that makes a lot of sense. So are there any sort of trends that you think will continue? We've already entered sort of this kinder, gentler era where at least people are offered some level of participation, even if it's not on equal footing.
And I take some credit for that, Jane. I do.
I give it to you.
I think, that folks know that we're serious litigators. We've turned down a lot of these cases. If the credit document doesn't stand up to it, then we tell people it's not worth it. You're going to lose. You didn't review the document carefully enough. And we've also advised equity sponsors who want to do more pro rata transactions, who don't want litigation and they want to avoid it, or even folks who are being asked to put in new money to join the party late, and they want to understand what the litigation risks. So we're not always on just one side of the transaction. But I just think the imperative to buy runway, the imperative, just the mentality, I think, where if you've invested in a company, if you feel your fiduciary duty is to maximize value for your investors, then the demand for this kind of creative transaction is going to continue. I think that the effort to avoid litigation. Particular, I think, for the participating lenders maybe went into these transactions with a view that there was very little downside for them. They got some goodies. They were going to hold on to them. And if it didn't work out, then they were better positioned at bankruptcy. I think what CERTA has introduced is the idea that maybe the company isn't going to cover be able to cover your legal fees. A lot of the credit agreements provide a duty of the lenders who receive a non-pro rata benefit to disgorge that if the transaction is disallowed. So I think there's a little more skin in the game for lenders, and I think that means that the consolation prize deals have looked better over time. I think that relationships continue to really matter for people who get to be in the in group versus the excluded group. And we're going to continue to see those types of transactions. So, I'm not predicting the demise of liability management, but I think whether there will continue to be big litigation over it really depends on how much sharing there is and what is the experience of a lender, for example, who accepts the consolation prize deal and then feels like they really are disadvantaged going into a bankruptcy. How lenders continue to view those less good, or tiered offerings, because now there's the in ad hoc group and the steering committee ad hoc group, and there are all kinds of different layers of participation. And so far, I haven't really seen that play out yet.
Yeah. And to your earlier point, I mean, how many times can you be someone who accepts the consolation prize and still go back to your client and say, invest with me, instead of someone who's always in the in group?
Yeah. That's a long-term perspective though, right? So, right. I mean, I've asked clients that question, to think about that. But I think it's very, very difficult. I think the other trend that we've seen, which makes this problematic, and I always disagree with strategies that kind of cut off people from information, right? So the NDAs that folks are getting asked to enter now, where they don't know what deal they're going to be offered going into it. I've had clients come to me and say, I thought I was getting in the in group, and I signed the NDA and I found out that was not at all what I was being offered. I think that really upsets some people. I think that the desire to limit the access to financial information about the company, that does not go over well. And I think it's problematic to ask people to make decisions without having full information. That will lead people to kind of hesitate before they sign the NDAs, I think, going forward, because they don't want to be duped, right? If you're burnt once on something like that, you're unlikely to do it again.
Fool me once, right?
Yes, exactly. So I just wonder if the deals, if there's a deal to cut, why can't you do it with giving everybody equal access to information so they can make informed decisions? And, then you tend to have rational acting.
Yeah. And so we spoke about the extend and exchange as something that's ripe for litigation, but is there any specific clause that you think could be like the next CERTA, that everyone is relying on it and it'll sort of change? I mean, when the Fifth Circuit ruled that the open market purchase couldn't be used for privately negotiated transactions, everyone had to sort of go back to the drawing board and say, well, how are we going to do this now? Yeah. Is there any specific clause that you think could be the next CERTA?
Yeah, well, I mean, I definitely think that the extend and exchange is one of them. I think we've continued to see a lot of drop-down transactions and sort of double dips. I think that's pretty standard. I think people try to, they try to draft provisions that protect against it, and there's very creative stuff that goes on. I do think that Mitel, it's a narrow decision, but it's certainly, if people wanted clarity in their drafting, then the purchase by assignment provision in Mitel was held to be a permissible way to do a non-pro rata exchange. So, if equity sponsors wanted clarity in the marketplace, then they would change the open market purchase provisions to just, these kind of exchanges, purchase by assignment. That language was approved, essentially. Now, I don't know if other courts would agree with it, but it's at least an opening there. I think another area that's ripe for litigation is really the question of whether the company is actually insolvent at the time the transaction is done, and whether there are fiduciary problems with doing a liability management transaction at a time when the company is actually insolvent. That raises a lot of questions of fact and a lot of expert analysis that has to be done. But sometimes these are done in secrecy in the dark of night and real extremis for the company. So it's a question that we're asking.
My final question to you is there any sort of lesson learned or any big takeaway from your experience in this space that you think people should know?
Well, I mean, I think there are economic factors in how the deals come together where there isn't a true, the people buying into the credits are not necessarily at the table, bargaining hard. And there are reasons for that. There was a time when it was just like people were just desperate to get their allocation and they didn't want to ruffle feathers. So, I tell folks that you've got to either, if you're not willing to ruffle the feathers, then you better choose your credits carefully. And, you probably should have experienced lawyers really scrubbing these documents a little more. Like, don't just rely on your checklist, right? Is like, does it have this provision? Doesn't have that provision? Because, the potential for ambiguity in these complex contracts is much greater than I think people had originally imagined. So you gotta really look harder. And some of our clients don't have in-house legal capacity, right? But it has happened more frequently now that people will send us a document and say, "What do you think of this document?" So, outside counsel is expensive. It's not, that's not what we do generally. But I would say invest in that if you're not going to bargain for a tight document.
Yeah, I've been saying for a long time now that hearing that there's a J.Crew blocker in the document means nothing.
Yeah, it's not enough.
There are so many different ways that those are worded, that they're worded, and that it doesn't, like, just a simple checklist of a J.Crew blocker doesn't tell you anything.
It's funny. What it reminds me of is when I studied tax in law school, and they tell you, like, the IRS is drafting these regulations, and there are just smart lawyers out there working all the time to find their way around them. Well, that's what's happening in your credit agreement. So you know that my great colleagues, our former colleagues at Kirkland, as you lay your head down on a pillow at night, there are really smart transactional lawyers trying to find ways to strip your covenants. So you should pay attention.
Absolutely. And with that, thank you so much for joining me. This was such a fun conversation.
Thank you, Jane.
And thank you to the listener. For any comments or questions, please reach out to podcasts@9fin.com.